all of you folks to this hearing to consider the nominations of John Eisenberg to serve as Assistant Attorney General for National Security, Brett Shumate to serve as Assistant Attorney General, Civil Division, and Patrick Davis, who I know quite a bit about, to serve as Assistant Attorney General for the Office of Legislative Affairs. Each of the nominees before us today has impressive qualifications, and we're looking forward to hearing from all of you. I'd like to thank your family and friends for coming today, and I know how proud they are of your being here in the position you've been appointed to. Mr. Eisenberg, you have impressive academic qualifications, degree from Stanford, mathematics, Yale Law School, and you clerked in the Fourth Circuit and later for Justice Thomas. Your academic pedigree is coupled with extensive experience in national security roles. From 2004 to 2009, you served with distinction at the Justice Department, focusing on national security, intelligence, and counterterrorism. For your service, you received the Attorney General's Award for Excellence and 2 Intelligence Committee Legal Awards. You then spent time as a partner at Kirkland and Ellis, and you did that before leaving your successful practice to serve your country again at the White House. You served with legal distinction and received awards for your service as legal advisor to the National Security Council, assistant to the President, and deputy counsel to the President for National Security Affairs. So, there's little doubt that you will bring great experience and expertise to the National Security Division. Your nomination has been praised by bipartisan groups of former Assistant Attorneys General of the National Security Division, including Matthew Olson, who served in the Biden administration. Mr. Shumate, you're well suited to serve as head of the Civil Division. You started your legal career clerking with Judge Edith Jones, Fifth Circuit, then entered private practice focusing on civil litigation and administrative law. In 2017, you were appointed Deputy Assistant Attorney General for Civil Division's Federal Programs Branch. In that role, you vigorously defended the rule of law and litigated issues involving federal agencies and the administration. After your time at the Justice Department, you returned to private practice for a better part of a decade before returning to the Justice Department earlier this year as the acting head of that civil division. I have no doubt that your service in government has prepared you well for the role you'll have been nominated for. Now, Mr. Davis, I just got done saying I knew a little bit about you, so I'm going to take this opportunity to introduce you before a couple of my colleagues will introduce the other 2. You're no stranger to the role you've been nominated to. As I well know, you're extremely qualified to serve as head of the Office of Legislative Affairs. You started your career in private practice, but you soon joined the Department of Justice to litigate complex cases in federal program branch for most of the Obama administration. While there, you gained an understanding of how the Justice Department works from the litigator's perspective. And of course, I'm told you met your wife there as well. A little over 6 years later, you joined my staff as an investigative counsel, and we worked on a lot together on our search for truth for the American people. You worked tirelessly to combat the weaponization of justice and to defend our nation's laws. You were instrumental in my investigation that the Planned Parenthood was violating federal law. Because of your work, the public could see these shocking discoveries for what they actually are rather than the false narrative. You also worked with me to show that Crossfire Hurricane was based on fraudulent, discredited information, actually paid for by the Democratic National Committee and the Clinton campaign. As reward for your efforts to uncover the truth, the Department of Justice secretly subpoenaed your records. You've been personally targeted for doing the right thing. When you left my office, you went on to serve the first Trump administration, where you worked on congressional oversight and the religious liberty task forces. Since then, you've gained valuable experience in the House of Representatives, working hard to uncover truth about COVID-19 pandemic origins and the private sector. But the thread that ties your service together is courage of your convictions. You stand up for liberty, equal application of law, values that I know you'll bring in your new role. I'm happy to see you go back to the department, and I know that you're ready for whatever that department throws at you. Indeed, I'm going to throw a thing or two at you now. As you're well aware, I am a rather frequent correspondent with the Department of Justice, and I look forward to you again in the service of the country and maybe fulfilling answers to my questions. The three nominees before us have impressive careers, and I look forward to hearing from them today. Now to Senator Durbin.
Thanks, Chairman Grassley. Before we hear from the nominees, I want to take a moment to speak about the ongoing attacks on the federal judiciary by President Trump and his allies. Last week, President Trump called for the impeachment of a federal judge simply because he ruled against the administration. He characterized that judge as a lunatic. The president was not alone. Elon Musk, the unelected co-president and the richest person in the world, has demanded the impeachment of federal judges dozens of times, and House Republicans quickly bent a knee and rushed to introduce articles of impeachment. I understand members of the Senate are also cheering that effort on. In response to this unprecedented attack on the federal judiciary, Chief Justice Roberts issued a rare statement. It read, and I quote, "For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose," end of quote. We cannot afford to wait and see if this president formally announces he will defy a court order. We must respond to this dangerous attack on our courts and judges now. Some right-wing activists have argued that impeachment is necessary because of the number of injunctions issued against President Trump compared to other presidents. They claim that this is evidence that federal judges are biased against this president. I would suggest there's a simpler and more plausible explanation. The number of injunctions issued against first and second Trump administrations is evidence of a president who repeatedly tests or violates the law. The danger posed by the Trump administration's attack on the judiciary is not abstract. I recall when there was a demonstration outside the home of a Supreme Court justice, we heard over and over again that we should never condone violence in the pursuit of political goals. I joined in that chorus on a bipartisan basis and hope to hell that my colleagues on the committee will do that today because we have this serious attack on the judiciary taking place. It's not abstract. The recent invective by the president and his allies has resulted in increased threats to the lives of judges and their families. This is unacceptable in a constitutional democracy. We can debate the value of nationwide injunctions and the merits of any particular judicial decision, but violence or threats of violence, whether from the right or the left on the political spectrum, are never, never acceptable. I urge all my colleagues on both sides of the aisles to join me in opposing this ongoing attack on the judiciary. Unfortunately, Attorney General Bondi and other officials at Justice have repeatedly shown that they will not defend the separation of powers. Their loyalty lies with the president. It should lie with the American people and the Constitution. The loss of an independent Department of Justice is not only a threat to the rule of law, it makes our country less safe. This is especially true of our national security. Since the start of this administration, every senior, career, National Security Division official has been removed from their position, every one of them. Following this purge, one former Justice Department official said, and I quote, "There's literally no one at home. The lights are off." That is a disturbing statement. It reflects a serious problem that cannot be easily fixed. Among today's nominees is John Eisenberg, who dropped by my office yesterday. We had an opportunity to discuss his aspiration to be leading the National Security Division. I hope for the sake of the nation, that Mr. Eisenberg is willing to place country above any personal allegiance to any political figure. We're also going to hear from Patrick Davis, nominated to lead the Office of Legislative Affairs. At her confirmation hearing, Attorney General Bondi committed to Chair Grassley that she or her top staff would, quote, personally review oversight requests from all members of the committee and do, quote, everything we can to respond to you. I have sent more than 20 oversight requests to the Trump administration. I have yet to receive a single meaningful response to the vast majority of them, including 7 to the Justice Department. When the shoe was on the other foot and I chaired this committee and they refused to respond to Chairman Grassley's similar request, I stood up for him and I was happy to do so. Whether you're on one side of the table or the other, you're entitled to the dignity of a request and professional treatment. Mr. Davis, I hope that you'll take that to heart. I'm also concerned about legal arguments Mr. Shoemate, who's been nominated to lead the civil division, has made since returning to the Justice Department. While all attorneys have a duty to zealously advocate for their clients, which of course includes the U.S. government, they must do so within the confines of the law. Yet in defending President Trump's executive order restricting birthright citizenship, Mr. Shoemate claimed any judicial order blocking it would be, quote, wildly inappropriate, his words. That is an unacceptable position for a Justice Department official to take, especially with respect to an order that is patently unconstitutional. As the judge presiding over the case stated, and I quote, I am having trouble understanding how a member of the bar could state unequivocally that this order is constitutional. The disintegration of an independent Justice Department before our very eyes, including the removal of key national security and counterterrorism officials, should be alarming on both sides of the table. The department is critical to protecting America's public safety and protecting the rights and liberties of all Americans. I hope to learn more about these nominees' commitments to these efforts and look forward to their testimony. Thank you, Mr. Chairman.
Yeah. Thank you, Senator Durbin. Now to Senator Graham for introduction.
Well, thank you. First, let's condemn violence directed at the judiciary. I'm all for that. Let's make sure that politicians, that we don't create problems for those in that branch of government, and I hope that would include the former majority leader going to the Supreme Court, and hurricanes coming your way. Of course, it can Kavanaugh. I didn't hear much back then, but yeah, count me in. As to this man, John Eisenberg, I have dealt with him to the newer members of the committee. He served in the prior Trump administration. I am completely confident you're the right person at the right time, John. When you look at his resume and his experience, you could not have chosen better. The world is literally in a dangerous place. The previous 4 years has been a disaster. Every conflict zone known basically has gotten worse, and we're going to have to clean up this mess that was created, and I think John Eisenberg will be a great counsel, not only to Pam Bondi, but to the president. A little bit about him. He's a national security expert. He's joined by his wife, Catherine, his son, Paul, and his daughter, Sarah. Welcome. He received a BS in mathematics from Stanford and a JD from Yale, which means he's very smart and a bit confused. He clerked for Justice Clarence Thomas from 2003 to 4. In the first term, he served as the legal advisor to the National Security Council, assistant to the president, and deputy counsel to the president for national security affairs, and Trump won. That's where I met John. I interacted with him a lot. He's reasoned, he's thoughtful, he's smart. I enthusiastically endorse this man. In recognition of his service, he received the Department of Defense Medal for Distinguished Public Service and the National Intelligence Superior Service Medal. He's held senior positions at the Department of Justice, including Associate Deputy Attorney General in the Office of the Deputy Attorney General and Deputy Assistant Attorney General in the Office of Legal Counsel. His service earned him multiple distinctions, including the Attorney General's Award for Excellence in Furthering the Interest of U.S. National Security and the Assistant Attorney General Award for Special Initiative National Security Division. Long story short, you can't find anybody better qualified than this man. Thank you.
He's not coming? Yeah. I'm going to read Senator Cruz's introductory remarks of Brent Shumate, a nominee for the Assistant Attorney General for Civil Division at the Department of Justice, because Senator Cruz is at another committee meeting. It is a distinct privilege for me, for Senator Cruz, to introduce the nominee for the position of Assistant Attorney General for the Civil Division at the Department of Justice, Brent Shumate. Before we dive into Brett's impressive professional qualifications, I'd like to take a moment to highlight the personal side of his story. Brent is a proud family man. His wife, Merritt, hails from San Angelo, Texas, and together they have 4 children, Finn, Whit, Everett, and Isley, who by all accounts are the biggest, is that Bucky fans? Okay.
Yes.
East of the Mississippi. Brett's in-laws, Milt and Deb Squires, are also proud Texans living in Denton. Brent's parents, Charlie and Barbara Shumate, are here with us today. Charlie, a Vietnam veteran, recently retired after a distinguished 50-year career practicing law in Virginia. It's clear that Brett's strong roots have shaped his dedication to public service and to his community. Brett's current role, acting Assistant Attorney General for the Civil Division, is not his first rodeo in public service. In fact, Brett has had a long and distinguished record of service to the American people. Brett began his legal career in public service, clerking for the distinguished Judge Edith H. Jones of the Fifth Circuit, where Brett developed a deep understanding of appellate law and a steadfast commitment to upholding the Constitution. Brett sharpened his litigation skills in private practice for a decade, rising through the ranks to become a partner. His colleagues at his first law firm, Wiley Ryan, described him as a skilled litigator, quote unquote, with quote, impeccable ethics and integrity, end quote. Brett returned to public service as the Deputy Assistant Attorney General for the Civil Division, Federal Programs Branch, 2017 to 19, where he was responsible for leading litigation on behalf of federal government in a wide range of cases. In his role, he handled some of the most critical and high-profile cases of the time in healthcare, national security, and regulatory enforcement. His experience managing complex litigation and advising senior government officials on litigation risk and strategy in this role makes him well qualified for this role. Between 2019 and 2024, Brett returned to private practice as a partner as yet another prestigious global law firm, Jones Day, where he focused on high-stake regulatory litigation involving the government, particularly in telecommunications and technology sectors. Once again, his colleagues, more than 200 of them, in fact, commended him to us. They wrote, "Brett is, quote, an intelligent and principled lawyer with unwavering integrity," and further quoting, "uncompromising commitment to the rule of law." Most recently, Brett served as acting Assistant Attorney General, Civil Division in DOJ. In this capacity, he quickly took on leadership responsibilities within the division, ensuring that the Department of Justice remain effective in carrying out its essential duties. Brett worked in this role, gives us clear proof of his capability to guide the division through significant legal challenges. It is this exact expertise on the job that led President Trump to nominate him to serve as Assistant Attorney General, Civil Division on a permanent basis. With his unique blend of experience in both private practice and public service, particularly in the Civil Division of the Department of Justice, Brett is exceptionally well prepared to lead this vital division. His track record in handling regulatory litigation, providing strategic legal counsel to government officials, and defending the administration's legal priorities across multiple sectors demonstrates that he has the expertise and leadership quality needed for this important role. Senator Cruz ends by saying, "I look forward to hearing from Brett today and strongly encourage my colleagues on the committee to support Brett's nomination to be the next Assistant Attorney General, Civil Division, Department of Justice." Thank you. Now, you folks that have just been introduced, would you please rise so I can administer oath? Do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? I got an affirmative answer from each of them, and I think we'll start out with Brett, and you can have your opening statement and introduce family and friends, and that's same for all of you.
Thank you, Chairman Grassley and Ranking Member Durbin, and to the entire committee for extending me the privilege of appearing before you today. My wife Merritt and our 4 kids are here today sitting behind me. Merritt will always be a proud Texan, no matter how many years we live in D.C., and she supported me and sacrificed for my career for over 20 years. My mom and dad are here as well. My father, Charlie, retired a few years ago, as you mentioned, Chairman Grassley, after practicing law for 50 years and serving his country in Vietnam. It's an honor for me to follow in his footsteps. I'd also like to thank President Trump and Attorney General Bondi for this nomination, which comes with the awesome responsibility of running the Civil Division, the largest litigating component at the Department of Justice. I've had the great fortune of working with many wonderful mentors throughout my career. My first job out of law school was clerking for Judge Edith Jones at the Fifth Circuit Court of Appeals. I'm also grateful to so many friends at Wiley-Rein for the mentorship in the early years of my career. At Jones Day, I had the privilege of working with many outstanding lawyers, including Don McGann and Noel Francisco. I'm grateful to them for their support and guidance during my 5 years at the firm. I've also been incredibly blessed to work with many outstanding lawyers and staff at the Department of Justice over the years. In fact, one of the best parts of the Civil Division is being able to work side by side with the career attorneys and staff who work incredibly hard and are dedicated to serving the American people. I had the privilege of serving as a deputy in the Civil Division from 2017 to 2019. During my time running the Federal Programs Branch, I worked for 2 outstanding leaders in Chad Radler and Jody Hunt. It would be an honor for me to follow in their footsteps if I'm confirmed to lead the Civil Division. Most people are familiar with the Civil Division because of the important work it does defending federal policies in the lower courts, but it does so much more. The Civil Division also uses the False Claims Act and other enforcement authorities to identify waste, fraud, and abuse in federal programs. It also does important work protecting consumers from elder abuse, illegal drugs, and fraud schemes. I look forward to doing this important work of the Civil Division if I'm confirmed. Thank you for considering my nomination. I look forward to answering your questions today.
Thank you, Chairman Grassley, Ranking Member Durbin, and members of the committee for holding this hearing to consider our nominations. Thank you as well, Chairman Grassley, for your kind introduction. I also want to thank President Trump for nominating me. It was an honor to serve as an appointee in his first term, and I'm eager to contribute to his second. I'm lucky to have my family here supporting me, and I'd like to introduce them. First, my wife, Catherine, who is a judge on the Court of Federal Claims. A little over 5 years ago, she sat here for her own confirmation hearing before the committee. Next is my daughter, Evelyn, who's in the 2nd grade, and my son, Henry, who's in the 5th. My parents, Dave and Pam Davis, have flown in from Nebraska to be here. And my in-laws, Todd and Meg Mason, have driven down from Pennsylvania to be with us today, too. I'm truly blessed to have such a wonderful family, and I'm profoundly thankful for their love and support. Having spent years as an oversight attorney for Chairman Grassley, it's humbling to be in this hearing room once again, this time as a nominee. The lessons I learned during those years, along with ones from my prior times in the Justice Department and throughout my career, have helped prepare me to lead the Office of Legislative Affairs, if confirmed. Under the Justice Department's regulations, the Assistant Attorney General for the Office of Legislative Affairs is entrusted with the duty of maintaining liaison between the department and Congress, reviewing, coordinating, and submitting departmental legislative reports, and coordinating the preparation and submission of proposed departmental legislation, among other responsibilities. I believe my professional experience lends itself well to these tasks, and I've seen many related issues from both sides. I have been a career DOJ line attorney and a political appointee in DOJ's management. I've been a Judiciary Committee staffer engaged in oversight of the department, and I've also been on the receiving end of congressional oversight. On both this committee and the House Intelligence Committee, I've examined numerous legislative reports submitted by the department, and at the department in the first Trump administration, I signed off on submitting many such reports. I've also conducted congressional oversight from both the majority and the minority and seen those differences as well. All of this is to say, I've worked extensively in both Congress and the Department of Justice, and I have a deep respect for their respective roles in our system of government. If confirmed, I would be honored to be given the responsibility to maintain and hopefully strengthen the working relationship between the two. To that end, I look forward to the opportunity to engage with the committee to advance important legislation to address our nation's ongoing challenges and to benefit the American people. I'm also acutely aware of the importance of the department being responsive to oversight inquiries from the committee, both from the majority and the minority. If confirmed, I'm committed to being transparent to the fullest extent consistent with the constitutional and statutory obligations of the department. Where the department appears to have been deficient in its oversight responses, I will seek to review the policies, procedures, and decisions that have caused the issues, consult with the relevant officials within the department, and pursue appropriate corrections. When there are conflicts between the department and Congress, the courts have recognized that each has an implicit constitutional mandate to seek optimal accommodation through a realistic evaluation of the needs of the conflicting branches in the particular situation, and to work not in a purely adversarial manner, but instead with a spirit of dynamic compromise to promote a resolution. I believe my experience in both branches will help me be an honest facilitator of that compromise process. As the chairman has often said, sunlight is the best disinfectant. I hope to help let the light in. Chairman Grassley, Ranking Member Durbin, and members of the committee, I've been privileged to spend nearly all my professional life in government service, and I hope you will see fit to confirm me for this next role to continue serving the American people, this time as an Assistant Attorney General. Thank you for your time and your consideration.
I would like to begin by thanking you, Chairman Grassley, and you, Ranking Member Durbin, for holding this hearing. I'd also like to thank Senator Graham, who's now invisible, unfortunately, for his gracious introduction, especially since my family was here. I would also like to thank President Trump for the honor of this nomination. I have some of my family here today, and I'd like to introduce them. I'm so fortunate to have the love of my life and my best friend here, my wife, Catherine. Where'd you go? Hi. Somehow she manages to have a full-time job and take care of everyone else in the family as well. It's no exaggeration to say I would not be here without her. Her support and encouragement throughout most of my adult life and during the hardest times has made all the good things possible and all the rest livable. My wife is joined by my son, Paul, and my daughter, Sarah. My youngest daughter, Evie, can't be with us today. She has something called 22q. It's a microdeletion on chromosome 22, which causes developmental delays, among a lot of other things. Evie is an inspiration to everyone who knows her, though. She doesn't let her disabilities get in the way, and she greets just about every day with delight. Paul and Sarah are not bad either. Catherine, Paul, Sarah, and Evie are the joys of my life. Without them, life itself would be unimaginable to me. I learned the importance of family from my mother, who, at all of 5 feet tall, was the most powerful person I had ever met in my life, and I think that still holds. No one wanted to mess with Rhoda. Because of her, my sister Nancy and my brother Ethan and I couldn't be closer. We talk virtually every day. We try to see each other as much as we can. While my mother passed away more than a decade ago, I'm fortunate to have both a father and a stepfather who are very supportive of me. I also have a very small number of friends who I count as family. They know who they are, and I thank them for their support. I would also like to say something about the colleagues. Too many to name here, I have had the privilege of working alongside in my many years in government service and during my private practice times. I am truly blessed to have worked with so many who are the embodiment of dedication, blazing intelligence, and integrity. Serving with each of them has been an honor, and I am grateful just to know these people. National security is the thread that runs through my professional life. I was in Alexandria on September 11th, 2001, when terrorists attacked our nation, resulting in the deaths of some 3,000 people in coordinated attacks on the World Trade Center and the Pentagon. I think it's hard for people who weren't adults in 2001 to understand the effect these attacks had on many of us. It's easy to forget that follow-on attacks were thought to be very likely and at times imminent. Indeed, our success in thwarting other attacks of that magnitude led many to wonder if the threat was overblown. But for me, I will never forget that day. I heard the explosion coming from a commercial airliner colliding with the Pentagon. I saw the smoke rising from that building. My wife couldn't come home from her office in Washington for hours because the necessary metro lines went through the Pentagon, and the Pentagon was still on fire. I saw F-16s trailing commercial airliners and even private aircraft, I suppose escorting them away from anything that they considered a target. But my country really had become a battlefield. In my past government jobs, I have focused on national security. The events of September 11th instilled in me the need to be part of a response to terrorism. My more recent government service has shown me the importance of protecting the nation from myriad other threats. I am deeply committed to the rule of law and the Constitution, but I also believe that the government has a solemn obligation to do what it can within those limits to protect the nation and its people. I was in the Department of Justice when it stood up the National Security Division, and I was part of a team that helped propose and implement necessary changes to bring NSD into the world. It would be a great honor to lead that division and the dedicated public servants who go to work every day in NSD, and who do so because they share the vision of which I spoke, that of protecting the nation. To everyone in NSD, I look forward to working together, should I be confirmed, to protect this great nation and its people from the range of national security threats facing them. I look forward to answering your questions.
Answer questions. I'm going to start with Mr. Eisenberg. And as he knows, and everybody on this committee knows, protecting whistleblowers is very important to me. I want to ask about a 2022 Department of Defense IG report claiming that you retaliated against Eugene Vindman for reporting President Trump's 2019 call with President Zelensky. I have serious concerns about the political motivations underlying the whole issue, and I have questions about the report itself, but I want to hear from you directly. How do you respond to the charge that you retaliated against Mr. Vindman?
Thank you, Mr. Chairman, for that question. First, I wholeheartedly deny the allegations. I'm just not that kind of a person. I would never let anything other than the facts of how someone's performing enter into an evaluation. If I had done so, I would not be here seeking this office. Let me note one other thing at the beginning. I was in the White House at the time. All of these events happened within that confines, and so virtually everything is subject to executive privilege. When the Office of the Inspector General called my lawyer to say that they wanted to interview me, my attorney advised me that we would need the permission of both the then current Biden administration and the former Trump administration. That's because they were the holders of the privilege, of that executive privilege. My attorney called them and sought that permission, but we didn't get permission until after the report, which sort of came out of the blue to us. We didn't get that permission until after that report dropped. Consequently, the Office of the Inspector General was wholly without with anybody telling that side of the story. I did not, and none of the other people that had allegations against them in that report were able to sit for an interview. Now, that stuff, that material is in general subject to executive privilege. But I feel like I could give a few examples of why my evaluation of Mr. Vindman changed just based on what's in the IG report, which is now public. As an initial matter, it's clear that I told Mr. Vindman at some point that in order to go to meetings over a certain level or about certain topics, he needed to get permission from either me or my deputy. But then we find out that Mr. Vindman would add himself to meetings, which means he was trying to get into that meeting, even if I had made even if I had made no determination, or actually a determination that he shouldn't be there. Meetings like this aren't like standard meetings within a company trying to figure out how much product to make this year. Those meetings have some of the most sensitive information that the United States government has. And the deliberations in those meetings can often be extraordinarily sensitive in and of itself. So you only send somebody to a meeting if they have something to add to that meeting. Otherwise, you're exposing someone to classified information despite the fact that there's no reason for it. And we're not supposed to do that. We even found out subsequently that Mr. Vindman went to a meeting after I had told him expressly not to go to that meeting. At another time, we found out that Mr. Vindman was seeking reimbursement for his brother's travel expenses to Ukraine. Both my deputy and I told Mr. Vindman that he couldn't do that there was an obvious conflict of interest. Nevertheless, we heard that Mr. Vindman continued to do that. Relatedly, we heard that and this is in the IG report as well, we heard that Mr. Vindman, that a particular witness reported that Mr. Vindman turned red in the face when he met, some resistance to getting money on behalf of his brother. I wouldn't tolerate that in my office if someone goes and tries to intimidate, yells, or anything. It's critically important that especially lawyers in the NSC act like lawyers. That's not everything by any stretch, but it's the stuff I can glean from the public report.
Mr. Shumate, I've got an opening statement. I'm going to just quote Justice Kagan on nationwide injunctions, quote, "It just can't be right that one district judge can stop nationwide policy in its tracks and leave it stopped for years it takes to go through the normal process," end quote. What is your perspective on the use of nationwide injunctions, and is there a role for Congress to play in ending the practice?
Thank you, Mr. Chairman, for that question. I agree with that sentiment. We've seen an unprecedented number of nationwide or universal injunctions just in the first 2 months of the Trump administration. The department's position has been consistent across administrations that single district court judges do not have the power to issue nationwide or universal relief. Our position flows from Article 3 of the Constitution, which limits courts to deciding the case or controversy before them. And courts are supposed to apply doctrines like standing and reviewability and scope of relief to award relief to the party before them and redress that injury, not go beyond the parties. But we've seen district court judges grant relief far beyond the parties to those cases to enjoin the executive branch nationwide or universally. And in terms of whether there's a role for Congress to play, Yes, Senator. The Constitution creates one Supreme Court, but vests in Congress the authority to ordain and establish the lower courts. And over time, Congress has certainly created courts, eliminated courts, created jurisdiction, limited jurisdiction, and created special review procedures for review of agency action, whether it's 3-judge courts or direct review in the courts of appeals. So certainly there is a role for Congress to play, Senator.
Senator Durbin.
Thank you, Mr. Chairman. The Justice Department is currently defending the Trump administration in a number of lawsuits challenging executive actions taken by the president and officials of the administration. Federal judges, both Republican and Democratic appointees, have enjoined some of these actions, holding they are illegal or unconstitutional. Alarmingly, President Trump, his allies, and even some nominees before the committee have responded by questioning whether the executive branch must follow court orders. If confirmed, the three of you will hold key positions at the Justice Department, and you will take an oath to uphold and defend the Constitution. So I'm going to ask a question which could merit a yes or no answer, and I hope it will. Do you believe, I'll ask each of you, do you believe a litigant, including the executive branch or president, can lawfully defy a court order? Mr. Shoemate. You want to turn down?
Thank you for the question. I will always advise a client, whether in private practice or in government, to comply with court orders. And if our client disagrees with the court order, we can appeal, seek a stay. And I think that's exactly what I've heard the president say: comply with court orders and appeal if we disagree with them.
Mr. Davis.
Thank you, Ranking Member Durbin. Yes, I would say parties to litigation should always follow lawful orders that bind them.
Mr. Eisenberg.
I agree with both of my colleagues.
Thank you. Mr. Eisenberg, earlier this week we learned about a shocking security breach in which the Defense Secretary Hegseth and other cabinet officials discussed highly sensitive military plans over a commercial messaging app known as Signal. Classified and otherwise highly sensitive national security information must be handled in accordance with strict security protocol, including the use of secure facilities and communication channel. Willful or negligent disclosure of mishandling of such information is a criminal violation of the Espionage Act. Do you agree that the Justice Department must thoroughly and impartially investigate this breach, and if criminal violations have occurred, that the department must fairly and impartially prosecute those responsible?
I agree that the department should take whatever appropriate action there is. I don't know enough about what actually happened to say what that action would be.
I'm asking whether you believe it should be investigated by the Justice Department.
In my view, it depends on the facts. Like, if the facts are completely different than has been reported, I don't know what the facts actually are, and I wouldn't want to opine on that until I knew what they were.
Mr. Shoemate, last year you participated in a Federalist Society panel discussion about the president's ability to remove heads of independent agencies. Do you recall that?
Yes, I do, Senator.
During that discussion, you argued that, quote, nearly all modern independent agencies are unconstitutional because of protections dictating that agency heads can only be removed for cause. Do you remember that position?
Yes, Senator.
You appear to suggest that a host of independent agencies should be subject to the whims of the White House, despite Congress's constitutional authority to create these bipartisan independent commissions. So do you stand by your argument that removal protections render independent agencies unconstitutional?
Thank you for the question, Senator. As I recall, I was appearing as a lawyer at a law firm who currently had a case before the courts where I was taking a position arguing that removal protections for a certain agency were unconstitutional, and I was appearing advocating for the courts to rule in my favor in that case and advocating for my client's position. Now in my role at the Department of Justice, I represent the interests of the United States. There is pending litigation regarding removal protections and whether those restrictions are constitutional. So I wouldn't want to go beyond what the department has already said in those cases, Senator.
The view you expressed last year directly contradicts the Supreme Court's decision in Humphrey's Executor, a 90-year-old precedent holding that removal protections for independent agency heads are constitutional. In February, the Trump administration informed me that it will seek to have this precedent overturned. did you participate in any conversations with any Justice Department or White House official about this plan to overturn Humphrey's executor?
Senator, in my role as the acting head of the Civil Division, I had many conversations with many folks within the government about many topics, but I don't think it'd be appropriate for me to discuss who I spoke with or what advice I gave on any particular matter to protect the deliberative process and to encourage individuals across the government to reach out to the Civil Division and seek our advice on particular matters without fear that those conversations will be disclosed
But
publicly.
I didn't ask you that. I didn't ask you who you spoke with or what you said. I asked if you participated in conversations about this case being overturned.
Senator, I don't think it'd be appropriate for me to disclose what matters I advised on at the department. I advised on many matters. I want to encourage folks throughout the government to reach out to the Civil Division to solicit our opinions without fear that those conversations will be disclosed.
Mr. Chairman, may I ask one other question?
Yeah.
Mr. Chairman, I'd like to ask Mr. Shumate. Last night, the president was asked as to whether or not the rioters on January 6th should be compensated. That's a matter that would fall in the jurisdiction, I believe, of your responsibility in the civil section. Do you think the January 6th rioters should be compensated?
Senator, I'm not familiar with those comments that the president may or may not have made last night. We have many pending cases in the Civil Division, including tort suits. It wouldn't be appropriate for me to commit to any particular resolution of any of those cases without talking to other folks within the department.
Well, I come down on the side of the law enforcement officials that keep you and me safe and your family as well at this moment, who were attacked by these rioters, and I do not believe they are entitled to any compensation for their action. Thank you, Mr. Chairman.
Senator Lee.
Thank you, Mr. Chairman. Thanks to the three of you for being here today and for your willingness to serve. Mr. Eisenberg, I'd like to start with you, if I could. During her confirmation hearing, Attorney General Bondi and I had a conversation about FISA Section 702 and about the use of what I sometimes refer to, for lack of a better word, as de facto warrantless backdoor searches, meaning searches of U.S. persons through a U.S. person identifier known to be a U.S. person identifier, to search the databases containing incidentally collected content communications involving U.S. persons, U.S. citizens, and others here in the United States, lawful permanent residents and so forth. And I asked Attorney General Bondi specifically whether she would agree with me that these de facto warrantless backdoor searches are concerning in that context. She responded in the affirmative with the word yes. That leads me to my question. Would you agree that these backdoor searches of incidentally collected communications involving American citizens are concerning?
Thanks for the question, Senator Lee. I certainly agree that it does raise issues that if you search a database, substantially large database. I don't at this point, however, know what protections are in place since I'm not currently in NSD. So if I were confirmed, I would talk to the experts in the NSD about exactly what they do, and I would then talk to the Attorney General and help come up with perhaps different procedures if those are warranted.
I appreciate that, and I would add here that for the entirety of the 14 years that I've been a United States Senator, the whole time I've served on this committee, I and others, including people on both sides of the aisle, including Senator Durbin over the years, we've raised concerns with this. On each occasion, we've had officials from the FBI tell us, don't worry, we've got procedures in place. You don't need to worry about additional legislation. We've got it covered. And in each instance, when they come back, they usually tell us, okay, yeah, we discovered there have been some abuses, but now we've really got it covered. The bottom line is I do believe Congress needs to act here. I think we need additional protections because those internal protections haven't worked. Because we're trying to ram a giant square peg into a round hole. It doesn't work. In my view, it is not compatible with the letter or the spirit of the Fourth Amendment to allow those sorts of things. Now, Mr. Eisenberg, you've spent much of your career in national security law. With that, you've got vast experience with the FISA court and the FISA Court of Review. What reforms, if any, do you think perhaps ought to be made to the FISA court or the FISA process?
Thanks for the question, Senator. I think this is something that I need to study as soon as I get into NSD, if in fact I'm confirmed. In my view, it has to be possible to do better in order to at least assure the American people that the sorts of privacy protections that are in place are actually working. But as to the actual details, I think I need to get in there first if I'm confirmed.
Gotcha. Mr. Shoemate, let's turn to you. For a long time, I've been troubled with Congress's chronic delegation of the lawmaking power. As you know, Article 1, Section 1 makes Congress the sole sovereign lawmaking authority within the federal government. Article 1, Section 7 makes that doubly clear by saying you cannot make a federal law without both houses of Congress passing the same legislation, bicameral passage, followed by presentment to the president for signature, veto, or acquiescence. Congress has deviated from that, and the courts have been unwilling to enforce that part of Article 1, Section 7 for reasons that escape me, while acknowledging that the non-delegation principle exists. They just refuse to enforce it. Now, in your Senate Judiciary questionnaire, you listed a case that you worked on called All State Refractory Contractors versus Sue. And in that case, you challenged the constitutionality of the OSHA statute. What can you tell us about your involvement in that case and what your involvement in that case sort of taught you, or what you gleaned from that as far as Congress's ability to delegate its lawmaking power?
Thank you for the question, Senator. Yes, so that case reinforced for me the importance of Article 1, the vesting of legislative power in the Congress. And in that case, we were representing a client, All States, which is a general contractor in Toledo, Ohio, that was challenging OSHA's statute, which under the non-delegation doctrine, which is a longstanding doctrine in Supreme Court precedent that says that Congress can't delegate its legislative power to the executive branch. And under the OSHA statute, Congress has allowed OSHA to promulgate numerous safety regulations that impacted my client. And so in that case, we were challenging the statute on its face as a violation of the non-delegation doctrine. We thought we had pretty good arguments. We went up to the Sixth Circuit. The Sixth Circuit upheld the statute in a 2-1 decision, and the Supreme Court denied cert in that case. So reinforced for me, Senator, the importance of the structural separation of powers and that each branch stay within their proper role.
Indeed. I see my time's expired, and I'll note as you say that this is not merely a hypothetical problem. 100,000 pages of new regulatory text issued last year. By some estimates, those 100,000 pages of new regulatory text put in place entirely by unelected, unaccountable bureaucrats cost the American economy $1.5 trillion annually. Think about that. That's a problem. Thank you, Mr. Chairman.
Senator Ronald.
Thank you, Mr. Chairman. As part of my responsibility to determine the fitness of all nominees who come before any of my committees, I ask the following 2 initial questions, and if we can start with Mr. Shoemate and go right down the line. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No.
No, Senator.
No, Senator.
Mr. Eisenberg, have you ever faced discipline or entered into a settlement relating to this kind of conduct?
No, Senator.
No, Senator.
No, Senator.
This is for Mr. Eisenberg. There have been calls, including from the authors of Project 2025, which I think is generally seen as a blueprint for this administration. But Project 2025 calls for the revival of the National Security Division of DOJ to revive the so-called China Initiative. If confirmed as head of the National Security Division, do you plan on reviving the China Initiative, yes or no?
I plan on looking at whether something like that should be stood up again, but I don't have any concrete plans about that.
Do you have any concerns about bringing back that initiative? Do you have any awareness of what that initiative led to?
I'm sorry.
In terms of the litigation that arose from the China Initiative during the first Trump administration? Just tell me yes or no if you have an awareness.
I did hear of some of it, yeah.
Okay, let me just say that the program was supposedly about countering Chinese government espionage and intellectual property theft, but it drifted far from that purpose. Instead, it focused largely on university professors, most of them of Chinese heritage, who had alleged paperwork errors in grant applications. And the Department of Justice, which usually has a really great track record in convicting the defendants, many of whom plead guilty. But in the case of the China Initiative, the conviction rate was very low, practically non-existent. So for the dozens of cases against basically Chinese professors that the DOJ brought, most of them were tossed out for lack of evidence. And we know that the China Initiative was misguided, a waste of resources, and seemingly based more on the ethnicity of defendants whose lives were in many ways just destroyed by DOJ going after them than on the crimes they supposedly committed. So I would say that if you're going to look into reinitiating the China Initiative, I would look at the history of this initiative and do not go there. For Mr. Shumate, you defended President Trump's birthright citizenship order as though by waiving an executive order he can get rid of the provisions of the 14th Amendment. You defended that order to get rid of birthright citizenship, and the judge that decided case called the argument that this order that Trump made blatantly unconstitutional. And the judge had difficulty understanding how any lawyer could make the argument that you were making. And 3 courts of appeals have refused DOJ's request to stay, so there are some pending TROs. The administration then went to the Supreme Court, and the Supreme Court has not weighed in yet and set a leisurely briefing schedule, suggesting that the Supreme Court doesn't consider the government's defense of the order to be worthy of quick consideration, which makes me wonder whether you are prepared to argue before these courts what one court already said were blatantly unconstitutional order. So, Mr. Shumate, is that what you're going to keep doing?
Senator, thank you for the question. Since that first hearing that Senator Durbin referenced earlier today, the department has filed many briefs explaining its view of the 14th Amendment and the legality of the president's birthright order. Because it's pending litigation, it wouldn't be appropriate for me to discuss the merits of the litigation.
I think that, you know what, I have to say, Mr. Shumate, that this is one order that was just, there's just a lot of precedent for birthright citizenship, and for you all to spend your time and resources going after this as a way to make a point, political point, basically, is not the way that I would expect the Justice Department to comport itself. Thank you, Mr. Chairman.
Mr. Shumate, what's a universal injunction?
Senator, a universal injunction is what we call an order from a court enjoining the government in a way that goes beyond the parties to the case, but applies nationwide or in some cases universally to enjoin the government.
Is it sometimes referred to as a nationwide injunction?
Yes, it is, Senator.
Okay. What's the statutory basis for a federal judge issuing an order that affects people other than the parties before the court?
I'm not aware of a statutory basis, Senator.
There is no statutory basis, is there?
No, Senator.
What's the United States Supreme Court opinion which interprets the Constitution in a way that allows a federal district court judge to do this? Can you name me that case?
I'm not aware of one, Senator.
There isn't one, is there?
I'm not aware of one, Senator.
Now, explain to me how this works. You have a plaintiff and you have a defendant, and the plaintiff files a lawsuit and goes in front of a federal judge. Federal judge has certain jurisdiction in personam and subject matter over the parties, the people, the plaintiff and the defendant. They're the only two people in court. How can a judge, a federal judge, issue an order that affects everybody else other than those in front of him or her? How is that possible?
It shouldn't be possible, Senator, but district courts do it all the time. I think on the theory that the courts need to enjoin a federal policy from going into effect, and they often will enjoin it as nationwide, so all non-parties are protected by that injunction.
I thought that if you wanted to affect parties who aren't in court, you had to file a class action.
That's correct, Senator.
So why don't the federal judges, instead of issuing a universal injunction with no legal basis, tell the plaintiff, look, you got to go file a class action if you want to impact parties who aren't subject to my court?
Senator, the Department of Justice makes that argument all the time in our briefs. I think in many cases class actions would be inappropriate. They wouldn't. The plaintiffs couldn't satisfy Rule 23 to establish a class.
So they couldn't.
Correct.
So they preferred to ask for a universal injunction.
Yes.
Okay. Does this encourage forum shopping?
Yes, Senator. Not only does it encourage forum shopping, but also district shopping and filing multiple strategic lawsuits to find one judge that will enjoin a single policy nationwide. Where if you have 5 lawsuits, a plaintiff, only one of those 5 cases needs to be successful.
And both sides, all sides, have used this as a way to forum shop, haven't they?
I think plaintiffs, regardless of administrations, will often file cases in the most favorable forum. Yes.
Okay, we've established that there's no basis in statute and no basis in Supreme Court precedent for a universal injunction. How about a common law? I mean, universal injunction is basically an equitable remedy. Did this exist in common law courts in England on which our law is based?
I don't believe so, Senator. I think the government has cited cases from the Supreme Court that says, courts are really bound by the scope of relief that a court in equity would have granted back in England before the founding, and the courts at that time would grant relief to the parties in the case, not far beyond the.
A universal injunction as a remedy is unknown in English common law, is it not?
I haven't done the research that far back, but I'm not aware of it.
I have. Okay. It's unknown. Wasn't part of equity. Only about 27 universal injunctions were issued in the 20th century. Does that sound about right?
That sounds about right, Senator.
But 86 of them were issued against President Trump in his first term. Is that correct?
I don't know the specific number, but they were a high number.
And so far in President Trump's second term, 30 universal injunctions have been issued against him. Have they not?
Senator, I don't have a specific number, but that sounds about right.
The universal injunction has become a weapon against the Trump administration, has it not?
Yes.
And tell me again in my last 10 seconds, tell me the basis for universal injunction in Article 3. I read Article 3. Which defines judicial power. Where does it mention universal injunction?
It does not, Senator. It says courts are to decide the case or controversy before them, which is based on the parties to the case.
So the Congress could act and say, look, federal judges, you render a decision to a plaintiff or a defendant, but you can't impact people outside of your courtroom other than through a class action. That's why God created class actions, isn't it?
Yes, Senator.
Thank you, Mr. Chairman.
You know how important oversight is to me, and I gave Bondi a binder of 144 oversight letters that I sent during the Biden Justice Department. And I know that's a big job for you to fulfill that, but I'd like to give priority for your committing to providing responsive document requests as opposed to just answering any particular letter right now, because a few of them asked for that. And for Mr. Shoemate,
Mr. Chairman, I have a question too for Mr. Davis if we're stalling for
okay,
time.
yeah, okay. The False Claims Act is very important priority for me because in 1986 I spearheaded legislation to substantially strengthen its civil provisions. That's the key TAM provisions in it. It has since brought $78 billion back into the Treasury, I think 3.9 just last year. More recently, I introduced the False Claims Amendment Act, a bipartisan bill that would fix loopholes that allow fraudsters to avoid accountability. If you're confirmed, will you pledge to vigorously enforce the False Claims Act and devote adequate resources to investigating and prosecuting false claims cases?
Yes, Senator, absolutely. The False Claims Act is an essential tool that the department uses to root out fraud, waste, and abuse. Key TAM relators are an essential component of that. As you know, the department generates billions of dollars in revenue every year for the Treasury through the False Claims Act. If I'm confirmed, I will aggressively enforce the False Claims Act and work with the outstanding folks in the fraud section.
I know after 9 years of one case being filed and it went into discovery, somebody in the previous administration just stopped it. We can't let things like that happen. If you're going for 9 years and going into discovery, you can't let some political person step in and stop the claim. It just is one example of some things that have been wrong. Senator Schiff.
Thank you, Mr. Chairman. Mr. Eisenberg, you served during the first administration as the NSC legal advisor. In that capacity, you must have participated in dozens, if not hundreds, of principal meetings organized by the National Security Advisor. Did you conduct any of those meetings by text chat that involved military strike plans?
No, I don't believe so.
So the entire first 4 years of the Trump administration, you never had a text chat conversation about plans to strike targets using an unencrypted or using a commercial app?
Well, I'm not aware of any such incident anyhow.
And you didn't do that because that would have been a terrible national security breach of protocol, would not?
I would have to know a lot more to know whether that would be a breach.
Would you really need to know more than a conversation about military targets, the time of the attack, the location of the targets, the ordnance being used?
Sure, you'd want to know whether the device is up to a certain level so that it could. I mean, you might make one that
okay, we're talking about a commercial app like Signal. Would it ever be appropriate to discuss imminent plans to strike military targets on a commercial app?
I still think it's very difficult to answer that question in the abstract. I mean, I can think of circumstances in which you could, sure.
Oh, well, give us a circumstance in which you can talk about an imminent military attack unknown to the public, where it would be appropriate to do so on a commercial app.
Okay, something absolutely urgent happens and needs to go right now, and your normal communication systems don't work. I mean, there's an example where you may have to do something like that.
And where you have access to classified facilities, it would be completely inappropriate, wouldn't it?
I still need to know more.
Really? Wow. And you want to lead the National Security Department at the DOJ, and you would need to know more?
Yes, Senator, I'd like to lead the NSD, and I think I'm exceptionally qualified to do so.
And do you fail to believe the NSA and the DOD when they say that the use of commercial apps like Signal is a security threat and inappropriate for confidential or sensitive data?
I haven't heard what either of those entities has said.
So you don't have any idea what the view of the intelligence community is about the use of commercial apps to conduct government business involving classified or sensitive national security information? You have no idea what the position is?
No, I'm sure the position is that in general that should never happen.
Okay, so what happened in this Signal chat should never have happened. Do you agree with that?
No, I said, as I said before, I would need to know more.
Have you read the Signal chat?
I have not yet.
Yeah, you have not read it. Are you desiring to be willfully blind to what just happened?
No, I was trying to prepare for this hearing, among other things.
Oh, and you didn't anticipate you'd be asked about this? Or is it because you anticipated you would be asked about this, you didn't want to inform yourself of this incredible breach of national security?
There are millions of things going on in the world at any given time, so I just didn't happen to learn about this one.
Oh, I see. There are millions of things going on. Yes, I'm sure there are millions of things going on in the world. But this happens to be probably the biggest national security story of the month, which included a lot of other national security stories, including a war in the Middle East and including capitulation to Putin and Russia. But you just happened to neglect to read this one. Is that what we're led to believe?
I just happened not to read it, that's all.
Well, let me ask you this. If you're using a commercial app to discuss the identity of targets, their locations, and that information were to become public, it could compromise those operations, couldn't it?
It depends on what the operation is and where in the operation.
Well, let's say an operation to strike targets in Yemen, Houthi targets that identify, say, a top missile operative and the location of the girlfriend's building. Those kind of specific details discussed on a commercial app could jeopardize that operation if it became public.
Yeah.
Isn't that true?
It depends on the circumstances. And
Well, I just gave you the
And that's why I'm not going to
circumstances.
answer a hypothetical question.
Well, it's not hypothetical. I wish to hell it were hypothetical. This just happened. This was shared with a journalist on a commercial app. You need more information than that? Well, how about discussing denigrating our European allies on a commercial app? Could that have diplomatic fallout?
I don't know the circumstances.
Really? So the vice president's conversations on this app, others joining in and disparaging Europe, this is completely new information to you. You're unaware. You can't comment on whether that could interfere with our relationship with our closest allies?
No, I heard of the incident. I just, at this point, hadn't had time to look at it closely.
Yeah.
I'm a lawyer, sir, and before I make decisions and form opinions, I need to look at the facts carefully.
Yeah, and you don't hide from the facts as a lawyer. And if you
Absolutely
want to
not.
head the
Of course
National
not.
Security Division at the Department of Justice, you don't stick your head in the sand when we've had a serious breach of our national security so that you don't have to answer uncomfortable questions.
That's
Mr.
not
Chairman, I yield back.
Thank you, Mr. Chairman. I do find it interesting that my Democrat colleagues are so enraged by this non-story and had nothing to say when we had a president who literally couldn't put two sentences together for 2 years. President Autopin was the commander-in-chief. No questions about his inability to construct sentences, let alone foreign policy. But here we are with a fake story. But this is what happens when you have a party that has reached actually not rock bottom yet. Not rock bottom yet. But they got nothing. Zero. No issues, no leader, fringe issues define them. So they're going to glom onto the story of the day. And quite frankly, it's embarrassing for them. Just like, by the way, these calls to, come out against violence. The only thing, district court rulings, the only thing that's been talked about are political solutions. The only person I remember standing in front of the Supreme Court calling for a whirlwind on Justice Kavanaugh and other Supreme Court justices that were followed up by assassination attempts of Supreme Court justices, that were followed up by violent protests outside their homes where they had to move out of their homes, was Chuck Schumer. And as long as we're denouncing violence, how about firebombing Tesla dealerships? This Antarctic kind of strain runs through the left. And to my Democrat friends, I feel bad for you because your party has been captured by a radical element that is pro-Hamas, that is pro-violence, that is firebombing, Tesla dealerships because they don't like that Elon Musk has actually found the grift out and is cutting it out. The NGOs that have laundered money for Democrat causes for years, it's all coming to an end and they don't know how to handle it. So anyway, as far as sort of some of these rulings, I would point out that in the most recent case with the Venezuelan thugs who've now been imprisoned in El Salvador, the apex of presidential power is, as Justice Jackson wrote in the Youngstown Steel case in his concurrence, is that the apex when you have congressional delegation or core Article II powers as commander-in-chief. And the district court, in citing the Alien Enemies Act, where whether wartime or invasion or predatory incursion, the president is acting within his authority, the district court has no more authority to tell the president he can't do that than they can, speaking of national security, directing troop movements or missile strikes. So when we talk about separation of powers, it does go both ways. It does go both ways, and there's been this obsession with getting all of you on the record about following court orders. The President of the United States has said he will follow court orders time and time again, but it's this desire to just stir up something because they have nothing. That's what's going on here. I did want to ask, with the time that I have left, Mr. Davis, you have done a lot of great work investigating a lot of things. The origins of COVID, I'm just curious. So when I was Attorney General of Missouri, we actually sued Communist China for unleashing the COVID pandemic. We received a $24 billion default judgment recently. But when we filed that lawsuit, it was interesting, the reaction. You were called a racist if you implied anyway that it leaked out of Wuhan, which was very obvious to most people. And now the intelligence community, who for some reason resisted that conclusion for such a long time, has basically said that's what happened. What do you think, as you were investigating this, what was behind that? What was behind this resistance to all the evidence and the obvious nature of the origins of COVID?
Thank you, Senator, for that question. I appreciated speaking with you yesterday. That was great. The report that I authored on the House Intelligence Committee about the origins of COVID, unfortunately, is still classified, so I can't really get into the specifics of what it found. We did do an unclassified summary, which, just given the nature of the underlying information, was unfortunately not terribly revelatory. I would note that when then President Biden instructed the intelligence community to do a sort of comprehensive review on the COVID origins, the subsequent report they put out and the declassified version of it, there were serious flaws with. And I think those flaws, you mentioned that individual components have changed their public view, but I do think that until there's more transparency about what was going on within those elements of the intelligence community, the people won't really know the full story, unfortunately.
Thank you. Well, it is also interesting that that Fauci played a very significant role in this, and maybe we'll be hearing from him in some committee hearings sometime soon too. Thank you, Mr. Chairman. Okay, so Mr. Eisenberg, Mr. Shoemate, Mr. Davis, thank you for your testimony today, and to your family and friends who've made the visit. We thank you as well. It's a momentous day, I know, in your lives, and we're excited about what's to come. For everyone's information, written questions to Mr. Eisenberg and Mr. Shoemate can be submitted for the record until April 2nd at 5 p.m. Written questions to Mr. Davis can be submitted for the record until tomorrow, March 27th at 5 p.m. I'll ask the nominees to answer and return the questions to the committee as soon as possible so that we can quickly schedule your confirmation votes. With that, this hearing is adjourned. Thank you.